Hi, thank you for joining us this morning. My name is Alexis Eichel, and I'm the Landlord Engagement Specialist at Tacoma Housing Authority. And we are going to have a presentation from the city of Tacoma. ChiQuata Elder will be talking to us about city of Tacoma rental housing ordinances. And we also have Raquel Sager here as well. Please note, we will be recording this webinar and we will pause for questions and answers at the end and share the recording and PowerPoint once, probably by the end of the week or sooner. Okay, so I'm going to hand it over to ChiQuata.
Okay, thank you.
Yep.
Oh,
and I'm going to share
Alexis.
my screen. Oh, sorry, I'm going to share my screen so we can see the PowerPoint. Give me a sec.
Thank you, Alexis. As she stated, I'm ChiQuata Elder. I am the Landlord-Tenant Coordinator with the City of Tacoma out of the Office of Equity and Human Rights. And I am responsible for the administering and the implementation and basically writing the rental housing code, which is Tacoma Municipal Code 1.95 for the city of Tacoma, which complements the state of Washington State landlord-tenant law, which is RCW 5918. We also have Raquel Sager, who is our rental housing specialist, who does the day-to-day intakes for the landlord-tenant program, which helps both landlords and tenants with their issues regarding landlord-tenant rental housing properties inside the city limits of Tacoma. You guys have to excuse me. I am not feeling my best today, but we're going to get through this. So today I'm here to talk to you about the city of Tacoma's rental housing code and how that affects you and housing inside the city limits of Tacoma. So Alexis, if you can go to the next slide. So I'm going to go through the timeline and the process. The city's rental housing code became effective February 1st, 2019. We provide information regarding the rental housing code, whether that's changes, updates, or any of those things via the rental business license, which any landlord who operates housing inside the city limits of Tacoma are required to have, and then also our rental housing webpage, which is www.cityoftacoma.org/rental housing code. There is a place there where you can register to get updates, and once we update anything on the rental housing code, we will notify you there. And then like when we are proposing any changes or when we have in sessions or outreach or things like that, we will post things there. So we implemented it in February 2019, and then we amended the rental housing code in July so that it would align with the state law that went into effect on July 28th, 2019, which was the rent increase notices, and then the notice to terminate tenancy if a landlord was going to demolish, substantially rehab, or change the use. And then we also amended it again on October 1st, 2021 to align with the state law that went into effect on June 11th, 2020, which was the requirement for deposit installments, and then May 10th for the just cause eviction that went into effect. So during this presentation, I'm just going to kind of go over what the rental housing code originally looked like, and then what it currently looks like, and then we'll touch on some things that we're proposing to change in the rental housing code as a result of what the current housing market and climate looks like. So what I kind of want to really point out is that the city of Tacoma's rental housing code aligns with the state law. A lot of landlords, there's a misconception that the city of Tacoma is doing something that the state is doing. We're doing something different than what the state is doing. Once we've implemented our city of Tacoma rental housing code, the state came behind us and they mirrored a lot of what we did. There's only a couple of things that we are doing that the state is not doing. And I'll point those couple of things out. So, okay, so what's in our original rental housing code is the distribution of information, which requires landlords to provide tenants with at the time of application, the website where the landlords can go to check if there's any code cases against the landlord or if there's any discrimination cases. And the reason why we do this is because we feel that a landlord gets to screen a tenant, so a tenant should be able to screen a landlord in the same way. Because if a tenant has, for instance, asthma problems and the house has mold issues or has any other kind of code violations that might not let them live there comfortably, they may not want to rent that property. Or if a tenant is disabled and there's been discriminatory practices at that property, they may not want to live there. So a tenant has a right to know these things before they apply to live there. So that's the reason why we put that into place. So once a tenant has been screened and they've signed a rental agreement and they are going to live there, the landlord has to provide a tenant with a hard copy of a booklet called Renting in Tacoma, and then they have to get the tenant's signature stating that the tenant received that. This booklet is going to outline the state law, the city of Tacoma's rental housing code. It has information in there on code compliance. It has information in there on how to register to vote. It has information in there on fair housing laws. So it's a bunch of different information. And the reason why we did that is because a lot of times tenants don't know their rights. But what we're also finding is that a lot of landlords have been operating business and they don't know the landlord-tenant laws either. So we found that with them having to provide this information to tenants, they're reading it and they're learning the laws too. So they're required to give this packet of information or this booklet to tenants and get their signature at the time that a tenant signs a lease, and that's every year. Or if it's a month-to-month tenancy, they have to give it to them yearly or whenever the law changes. So if we update the law, they have to give it to the tenants every time the city of Tacoma updates the law. And it has to be a hard copy. However, if it is just an update of the tenant of the city updating the laws, you can give that copy electronically. But if it's the yearly renewals or the month to month, those ones, you have to give those in a hard copy. It can't be an email or anything like that. You have to give a physical copy to the tenants and they have to have signed for it. And then the third thing is if you're going to serve any notice that can lead to eviction, you have to provide the tenant with a form that's called a notice of resource. And what that form does, it explains to the tenant what that notice is, how they're supposed to respond to that notice. So if it is a 14-day pay or vacate notice, it explains to the tenant exactly what that notice is, how they're supposed to respond to that notice, and where they can get resources to get assistance for that notice. And when we were drafting the rental housing code the first time, what we found is that a lot of tenants will get notices from landlords and they believe that because they didn't come from the courts or stuff like that, they would ignore the notices and they would get notices and they would wait till like the very last day for something to seek assistance. So this was suggested by one of the landlords that was on my landlord's stakeholders group, or my stakeholders group, that we provide something to the tenants to help them, not ignore these notices, to help them, learn how to respond to these notices. And it has been very helpful because we do get a lot of calls from people that get this notice seeking assistance. So it has had an impact with tenants. So then the next thing on the rental housing code is a landlord must review and comply with all reasonable accommodation requests as outlined in Tacoma 1.29.120D. So if a tenant requests a reasonable accommodation, which is under fair housing laws, a landlord must review those and comply with them. So then the next one is deposit requirement and installment payments allowed. So that's 1.95.40. And then that is also state law, and that went into effect June 11th, 2020. So the rental agreement must be in writing, and the landlord must have a move-in condition checklist. If the move-in cost exceeds 25% of the first month's rent, and the tenant is on a fixed month lease, the tenant may pay their first, last deposits and all of that in 3 equal payments. If it's a month-to-month rental agreement, they may pay it in 2 equal payments. And the one thing about this is that the tenant must request it in writing, and the landlord cannot deny it. So landlords are not required to offer this, but the tenant has to request it in writing. And if they request it in writing, the landlord cannot deny it. Next slide. So the notice to increase rent, it's a 60-day notice. So if a landlord wants to increase the rent in any amount, it's a 60-day notice, and that's also state law. So notice to terminate tenancy, if you want to substantially rehab, demolish, or change the use, and that does not include selling of the property. That's a 120-day notice. And then that's also state law, and that went into effect July 28th, 2019. And then under the city of Tacoma, we have the tenant relocation along with the 1.95.070. If you're going to displace a tenant because you're going to demolish, substantially rehab, or change the use of the property, you must pay relocation costs if the tenant is low income. So what that means is the landlord would pay $1,000, the city would pay $1,000, and that is in the state law. And if jurisdictions choose to have that if they choose to have that program, and the city of Tacoma does have that program. And then the city of Tacoma also has in our code, which is in state law, if the property is deemed uninhabitable by a code enforcement official, the state law says that a landlord has to relocate a tenant in the amount of $2,000 or 3 times the monthly rent, whichever one is greater. And the landlord is fully responsible for this under RCW 5918.085. And so the city of Tacoma, we won't pay any of that, but we will enforce on that if the landlord, so if our code enforcement officers come in and we deem this property uninhabitable and it's due to something that should be the landlord's responsibility and not due to anything the tenant has caused or something that is done by an act of God, the landlord would have to relocate that tenant. And if the landlord does not do it, the city will enforce on that. So then the next one is we have our enforcement and compliance, which is 1.95.090. And that's the we have retaliation under there as outlined in the state law RCW 5918.240 and 2.05. And this is if the landlord takes any adverse action against the tenant within 90 days for exercising their rights under the law. And then we also included a tenant's right to organize, because what we were finding during some of these outreaches when tenants were starting to band together to try to get laws changed or whatever. Landlords were starting to retaliate against tenants for doing so. So we threw in the right to organize in our code. So if a landlord takes any kind of adverse action against a tenant, and that those adverse actions can include terminating their tenancy, they can include increase in rent, refusing services, anything like that. So if a landlord chooses to do any of those things, the city of Tacoma can enforce on a landlord for doing any of those things in our code, whereas a tenant under state law would have to take civil action against a landlord. Next slide. So that's the original code that went into effect in February of 2019. So with the recent changes that just went into effect in October of 2021, the biggest one was the just cause eviction that just went into state law. So the city of Tacoma, we adopted the just cause eviction, whereas before a landlord could wake up in the morning, didn't have to have a reason, as long as it wasn't discriminatory or retaliatory. They could give a tenant a no cause notice, and they didn't have to put anything on that piece of paper other than I want my property back. And as long as they serve the notice the correct way, they could do that. Now the law says that the landlord has to have one of 17 justifiable business reasons to terminate a tenant's tenancy. And that law went into effect on May 10th, 2021, and it was codified into RCW 5918.650. And then there's 17 just cause eviction reasons, and then it does allow no cause notices in 2 situations. And then the city of Tacoma, we adopted it effective October 1st, even though it went into the state law on October 10th. We adopted it into our laws on October 1st, which allowed us to do enforcement on it, because it's, even though it was in effect at the state level on May 10th, a tenant would have had to take civil action against the landlord. But by us adopting it into our law, our code on October 1st, it allowed us to take enforcement measures against the landlord who are in violation of the just cause eviction provisions in the law. Next slide. So as I explained, there's 2 situations when a landlord doesn't have to have a cause to terminate someone's tenancy. And one of them is if the tenancy is for a fixed term lease of 6 to 12 months, and then it rolls over to a month to month by the term of the rental agreement, and no cause is allowed with a 60-day notice, but only at the end of the initial 6 to 12 monthly term. So if it's a first 12-month lease, the landlord can give a no cause notice. If it's a 6-month lease, the landlord would have to wait until they do a second 6-month lease. So it has to be at least 12 months before a landlord can do a 6-month lease. A no cause notice. Okay, so then the first 9-month lease, the landlord can't do a no cause notice. And then if they do, it becomes a month to month for a few months, then they can't do a no cause notice. Or they can do a no cause notice, I'm sorry, and then 60 days. So anytime, if it rolls over into a month to month at any time, the landlord can't do a no cause notice. Okay. Hope I explained that correct. Okay, next slide. And so then situation number 2 is if the tenancy is for a fixed term and does not roll over into a month to month. So first 12 months, second 12 months, third 12 months. no cause notice. Like if it never rolls over into month to month at any time, and it's just consecutive fixed term leases, you can give a 60-day no cause notice at any time. You're on a 6 month lease. For the first 6 months, you can't give a no cause notice, but then the second 6 months, you can give a no cause notice. And then the third 6 month, you can give a no cause notice. So if it never turns into a month to month, you can give a no cause notice. So you'll have the slides there to give you an example, but we always suggest that you contact your attorney to make sure that you're doing these correctly, because if you don't, you can find yourself before a judge and losing in court. So always seek legal advice before you issue any notices to make sure that you're doing it correct. So now we're going to get into the legal causes that will allow you to terminate tenancy under both the state law and the city of Tacoma's 1.95. So it is the 14-day pay or vacate. And that's the rent, includes the monthly charges such as utilities. And if the tenant defaults on the deposit installment or the repayment plan under House Bill 5160. So those are things that you can give a 14-day pay or vacate notice. The breach of the lease, which is the 10-day comply or vacate notice. Non-breaches of monetary leases. So non-monetary. So you cannot put any money on a 10-day comply or vacate notice. So these are things such as noise violations, smoking in the unit, anything like that. You cannot put like late fees or rent or anything that is non-monetary can go on a comply or vacate notice, but you cannot put any money on a 10-day comply or vacate notice. I know landlords used to do it before, but you cannot do that anymore. The 3-day for waste, nuisance, or illegal activity. So this is the one where tenants don't have the opportunity to cure. So that's like the most egregious ones that you can think of. So like the nuisance, the interference of the ability of neighbors or the landlord to use or enjoy the premises. The next one is the landlord or an immediate family member wants to occupy the unit. So that's a 90-day notice. So that is the landlord's family. The landlord does not have another place that's available. They must live there for at least 90 days or at least 60 continuous days during the 90 days immediately following after the tenant vacates. So you have to be careful with this one, because if you give this notice just to get the tenant out and then you don't actually live there or whatever, you can face penalties and look at it as if you just use that as a way to get the tenant out. So if you're not really going to live there and you're just using this, it could be a way for you to be in violation of the just cause eviction, and enforcement can be brought against you. Next slide. Intent to sell. 90-day notice to vacate. If this is a single family home, so if you're going to sell the property, you have to serve the tenant with the 90-day notice to vacate. The landlord must take steps to sell the house within 30 days after tenant vacates, listing the house to sell at a reasonable price. And then you can, if you take it off the market and rent to someone else within 90 days, it looks like you were just trying to get around the just cause eviction provision. So I would be careful with that too. So you would have to, if you have to you can't take it off the market and rent it to somebody else within 90 days of the tenant vacating. So you have to be very careful with these. And so we kind of talked about the 120-day notice already. If you're going to substantially rehab, demolish, or change the use. Next slide. Conversion to condominiums, that's a 120-day notice. So if you're going to plan to change your rental property and make it into a condo. So if the premises is condemned, so if the city of the Tacoma or your local jurisdiction, well, in this case, it will be the city of Tacoma, condemns the property, says that it's unlivable. Sometimes it could be sooner than that. Sometimes we have to take immediate possession because of health and safety reasons, but you can give a tenant a 30-day notice to vacate because of the city saying that people can't live there. Shared space. If the landlord shares a space with the tenant, such as a kitchen or a bathroom, the landlord can give the tenant a 20-day notice. However, in the city of Tacoma, if the landlord rents four or more tenants in the same dwelling, the landlord must use one of the other causes to terminate tenancy. Because what we're finding is a lot of landlords will live in the property and they're renting out rooms. And so even though they may share the kitchen and the bathroom, you're renting out rooms to 5 other people. That's no longer a roommate situation. That's a multifamily property situation now. So you can't say it's a roommate situation anymore. So you now have to use one of the other causes to terminate tenancy, and you can't use the 20-day. Transitional housing, 30-day notice if you're in a transitional housing program and the person no longer qualifies for the program. So failure to sign a new rental agreement or a lease agreement, 30 days. So if I as a landlord come to you or you as a landlord go to your tenant and you give them a new lease or agreement to sign, and it's a reasonable lease and the tenant refuses to sign the rental agreement, you can give them a 30-day notice to vacate. But you do have to keep in mind that if the new rental agreement has rent increases in it, you have to give them that 60-day notice as outlined in the state law and Tacoma Municipal Code. But if a tenant is given a reasonable lease and they refuse to sign it, you can give them a 30-day notice to terminate tenancy. Next slide, please. Application fraud, 30-day notice to vacate if a tenant provides intentional, if they intentionally provide false information on a rental application. And then the landlord would have denied the application based on this information. So you can give that tenant a 30-day notice to terminate tenancy. And then other economic and business reasons, you can give the tenant a 60-day notice. The landlord has a legitimate business or economic reason to no longer rent the dwelling not covered under any other cause. I would be very careful with this because you usually can find another reason under this. And so you would have to really be able to explain to a judge what your other economic and business reason is. So this one is one that isn't used very often, and you would have to really be able to explain why it doesn't fit into one of these other 16 reasons. Repeated violations. So if you've had to give your tenant 4 or more 10-day comply or vacate notices within a 12-month period, that would give you the right to terminate their tenancy with the 60-day notice. Next slide. So if your tenant must register as a sex offender during the tenancy, or the tenant did not disclose that they were a registered sex offender on their application, you can give them a 60-day notice to terminate tenancy. And then sexual harassment. If the landlord believes that the tenant has made unwarranted sexual advances or sexually harassed the owner, the tenant, or another the manager or another tenant in violation of the lease, they can give the tenant a 20-day notice to terminate tenancy. And then holdover tenant. So if you have a tenant living in a rental unit for 6 months or more with an original tenant who moves out, and then you can give the remaining tenant application to submit. And then if they don't submit it, or if they don't qualify, you can give them a 30-day notice to terminate tenancy. Next slide. And then other changes. The state law recently put in that they've always had a section in the state law where there was illegal provisions. Now there's something that has gone into the law that says that it's there's penalties associated if a landlord has any illegal provisions in their rental agreement. So we at the city are saying that if you have any of these illegal provisions in your rental agreement, we can enforce on you. So you should know what provisions you can and can't have in there that are illegal. So if you have any of the illegal provisions that are outlined in 5918.230, as it currently exists or amended in the future, we will be able to enforce on you because you should not have any of those illegal provisions in your rental agreement. And then also the state law has put in there that it's a violation for a landlord to require a tenant to give more than 20 days notice to terminate tenancy. I know in the past, landlords have required tenants to give like 30-day notices and things like that. And tenants can agree on those things and they can give those types of notices. But if a tenant were to come and give a landlord a 20-day notice and a landlord tried to penalize the tenant, that would be unlawful because of the rental housing climate, units aren't staying that long. So tenants aren't able to, find housing that quickly. So we, the law says that, so we will enforce on landlords. We will enforce on landlords who are requiring tenants to give more than notices. I've seen landlords who are saying that we want tenants to give 60-day notices. And as landlord, you're not holding rental properties for 60 days for anybody. So to require a tenant to give a 60-day notice to terminate tenancy is just unreasonable. So those are the changes for the rental housing. That's the rental housing code. But like I said, we have an enforcement mechanism to ours. And so under our rental housing code, the enforcement mechanism is the penalty is $500 per day for per unit for the first violation and $1,000 per unit for the second violation in a 3-year period if you violate the distribution of information, the deposit requirements, the reasonable accommodation, and then a notice of rent increase. And then $250 per day for the first 10 days of non-compliance and $500 per day and beyond for 10 days of non-compliance for notice to vacate, tenant relocation, retaliation, illegal provisions, and requiring tenants more than 20-day notice to vacate. So those are the penalties associated with each of these violations. Next slide. So the City of Tacoma's rental housing code, it only applies to rental properties inside the city limits of Tacoma. The rental housing code, again, only has an enforcement mechanism where the Residential Landlord-Tenant Act only has civil remedies. The City of Tacoma, we only can enforce on violations of our rental housing code. The tenant must follow the steps under the Residential Landlord-Tenant Act in order to use the enforcement mechanisms under the rental housing code, which includes proper notice to the landlord, dispute properly with the landlord. And then the City of Tacoma can only enforce violations of our own codes, which include our rental housing code, our building code, which is Tacoma Municipal Code 2.01, and our discrimination code, which is Tacoma Municipal Code 1.29. And then enforcement looks like what happens is we will serve the landlord with a notice to come into compliance. If the landlord does come into compliance, if they don't come into compliance, we will serve them with the penalty. One thing we want people to understand, and we explain this to tenants, is that the rental housing code enforcement can't make landlords change their practices, but it does give the tenants a defense in court. So like if we have to enforce on a landlord and then the landlord and the tenant are going to court, it does give that tenant a defense in court. So it's going to be able to, the tenant's attorney is going to be able to use that as part of their defense in court to show the judge that the landlord was in violation of something that mirrors what the state law says and the city code, and that the landlord had the opportunity to come into compliance and they chose not to do it, and enforcement actions had to be taken against them. So it doesn't make a landlord choose to change their business practice. We've had landlords that they always come into voluntary compliance. That is our first choice. Enforcement is our last resort. If I can get a landlord to come into voluntary compliance and we never have to enforce on anybody, that is what we would choose to do. But the enforcement mechanism is there for a reason, and it does give a tenant the right for a defense in court, because we want to keep people housed. And for a landlord, we want you to be able to run your business effectively. And the only way that you can do that is if you're following the laws and if you know the laws, because that protects your property as well. So next slide. So Alexis, this has nothing to do with the rental housing code, but it became a law the same time that we passed the rental housing code. And she said that there's a lot of questions around the source of income. And so source of income became a protection in the state law. They put it in the landlord-tenant law, which was a crazy place to put it. If they were going to make it a protection, they should have put it in the state law under the fair housing laws with the Washington State Human Rights Commission. However, they put it in the landlord-tenant laws under RCW 5918.255. And that became effective September. COT means City of Tacoma. I'm sorry. So, so that became effective 9/30, 2018. So with that source of income, it means that a landlord may not, based on a source of income of an otherwise eligible prospective tenant, refuse to rent or evict or make distinction, excuse me, in the price or terms and conditions, present a dwelling or not available to rent, refuse to accept Section 8 vouchers or subsidy, intimidate, threaten, or interfere with the enjoyment of the dwelling. So basically what this means is like the days of a landlord being able to say, I don't accept Section 8 is over. That ended on September 30th, 2018. So I know before landlords could choose whether they wanted to do it in Tacoma or not, there were only a couple of jurisdictions that had the requirement. King County, Seattle, they had those protections for a long time, but effective September 30th, 2018, the whole state was required to accept Section 8. And so when a landlord is screening a tenant, so like if your income level is a tenant has to make 3 times the monthly rent, you have to take the voucher part off first when calculating the income. So if the rent is $1,500 and the person has a voucher for $500, you have to do the 3 times the monthly rent off the $1,000 and not the $1,500. versus the 50, where it would be the 1,500. So like if they have a voucher, so like if the rent is 1,500 and you would normally calculate the rent 3 times the monthly rent. So it normally would be 1,500 times 3, but they have a voucher for 500. So now you would take the 500 off before you calculate. So it would be 3 times the 1,000 instead of 3 times the 1,500. So that's how you would do your calculations. And then under the violations part, if you violate this, the state law says that you can have civil action against you up to 4.5 times the monthly rent, court costs, and reasonable attorney fees. So a tenant can sue you and get 4.5 times the monthly rent, court costs, and reasonable attorney fees. However, the city of Tacoma, effective February 1st, 2019, we added this to our discrimination code, which is 1.29, as part of our protected classes. So it's just like race, color, religion, national origin, mental or physical disability. So if a tenant were to call and say that I went to look at a property and I had a Section 8 voucher and they refused to rent to me, they could file a discrimination claim in our office, just like they would be able to if they had said that they wouldn't rent to me because I was disabled or because I was Black or because I was a woman. It's the same thing under the fair housing laws. So what would happen is an investigation would be open, and if you were found to have discriminated against this person, there could be monetary damages. It could end up in mandatory training, and also the tenant would still have the right to file that civil action against you. And if they have a fair housing claim that has been found against you, it makes it a little easier for them to file a civil action against you now because they have the proof. So you kind of don't ever want to be on the other end of a fair housing claim. So kind of follow the laws, get the trainings and everything. And if you don't know the answer, or if you have questions, our office is always open and available for you to contact and get, your questions answered around fair housing at all times. Next slide. So go back one, Alexis, you went too far. Yeah. So as I explained earlier, the city of Tacoma, we are always looking at housing is an essential need inside the city limits of Tacoma. And so we're always looking at what we can do to make sure that housing is safe, effective, healthy, and that our neighborhoods are vibrant in the city of Tacoma. And so we take a look at that, and then we look at the rental housing code and like what we might have missed and like what has been proposed at the state legislation and what was passed and wasn't passed or whatever. And so we take those things into consideration with the types of phone calls we get. And then we look at that, and then we consider things that we could put into place. So these are some of the things that we are considering putting into place in the future as it relates to the rental housing code. So shared housing, as you guys all know, the housing market in Tacoma has become very difficult. Like the rent prices are sky high in some places. So some people can't afford to live on their own. So shared housing has become a thing. And so what we're finding is that people are sharing spaces, and we want to ensure that they're living in spaces that are authorized spaces to live, because we have people that are renting out basements and renting out attic spaces and spaces that aren't livable. And so we want to make sure that if you're living in a shared space, you're living in an actual authorized space to live in. What we're also finding out is that people will have one person that will rent a house, and then they're renting out rooms. So they're subletting to other people. So they'll have what's called a master lease. And the people that are subletting are paying the person who has the master lease with the owner. And when the owner, they're paying their rent, and then the person who's has the master lease isn't paying the owner. And so when the owner goes to evict the person that has the master lease, the tenants who are subletting aren't aware of this. So sometimes they're not even aware that an eviction is going on until the sheriff comes over to say that y'all got to go. So we're trying to figure out a way to make sure that everyone who lives at a property knows what's going on with it at all times. So like if a notice is served on the person who has a master lease for eviction, all tenants who are living there are served notices so that they are aware and they're able to seek assistance. Preventing overcrowding in residential neighborhoods. Some neighborhoods are zoned just for single family housing and things like that. So like when you have people renting to 13, 14 people, that can overcrowd neighborhoods when 13, 14 people are living in a house and there's 13, 14 cars, you know, in those neighborhoods. And then again, I said like living in healthy conditions and stuff. So late fee standards, how landlords address late fees during tenancies. What we found sometimes is that tenants will have late fees and then they're not aware of them. And then a landlord will wait until right before a tenant gets ready to move. And then the landlord will hit a tenant with all the late fees that they've ever owed. And then that can be a barrier for a tenant finding another place to live, because they'll report this to the next owner. And most landlords will not rent to you if you owe another landlord rent. So we're trying to figure out a way that landlords have to notify tenants during tenancy, you know, of the late fees and stuff that they owe on a consistent basis. Or like, and if they don't do that, like they waive their right to collect these or report this to, you know, future landlords. Or even where in the Residential Landlord-Tenant Act, there's a limit of $75 already on how much a landlord can collect for late fees. So we've even thought about maybe we should do that. That wasn't our first thought. We weren't trying to limit how much a landlord can charge for late fees, but that was brought up by one of the people on the stakeholders group that was actually a landlord that was like, well, the RLTA, which is the Residential Landlord-Tenant Act, already has that in there. So is that something that we should consider? So we're just looking at a bunch of different things. The proposed sale of low-income housing. When housing that is already houses low-income tenants, we want those properties to notify the city of Tacoma so that we can notify low nonprofits and the housing authorities so that they can have the first right of refusal, excuse me, to purchase that property. So that way we can keep low income housing stock in Tacoma. That way also we can look at ways of helping those low income tenants prepare just in case they may have to move, or we can give them resources to prepare just in case the new owners that come in may be looking to, you know, raise rents or, you know, terminate tenancies, like different ways that we can assist the tenants that are living in the property on their rights and different things like that when they notify the city. So that would give us ways to be able to help these tenants that are living there prepare on how they can advocate for themselves or what their rights are. Next slide. So as you guys know, the state law is 60-day notice of rent increase of any amount, and that landlords are increasing rents 100%, 200%, 400%, and that's perfectly legal because rent control is against the law in the state of Washington. So we can't put a limit on how much a landlord can increase the rent. The only thing that we can do is put provisions around what the how much notice a landlord can give when they're going to increase the rent. So in the state law, at the legislative level, this last legislative level, there was something in the law that they were trying to move forward on notices requirements, and it didn't go through. So we're looking at some on our own. So like if a landlord is going to give, so these are some of the things that we've talked about. If they're going to give a notice of 6% or less, it's just the regular 60-day notice. If it's going to be anything over 6%, they're required to give anything between 180 through 220. And then one thing right now, the law doesn't require a landlord to serve a notice of rent increase in any particular way. One thing that we are going to require the landlord to do is to serve the notice in accordance with RCW 5912.040, which is either personal service, post it and mail it. So that way that they have proof, because right now landlords are emailing, they're just calling, they're texting, that there's no standard way of landlords notifying tenants of rent increases. And so we want them to be able to properly serve these, because sometimes they're getting missed, and then tenants are getting notices because they're missing them. And so then they're getting like the non-payment notices because they're not paying the increases because they didn't realize that their rent went up because they weren't properly served. And then another one that we are considering that was at the state level, they were trying to get through at the state level, is that waive the right for the tenant to have to serve the 20-day notice to terminate tenancy and not be penalized if they are going to vacate the unit based on the fact that of a rent increase. So like if a tenant they got a rent increase and they found another place to live, and because they couldn't afford the rent increase, and they found a place to live and they weren't able to give the standard 20-day notice, the landlord wouldn't be able to penalize them, as it outlines in the RCW, which says that if the tenant doesn't give the proper 20-day notice, the landlord can hold them liable for the next 30 days of rent. So if it's only in this case, the tenant would, the landlord would waive that right to penalize the tenant for that reason only. So we're looking at that. And then the next one would be restrictions on felon evictions if the housing provider does not have a valid City of Tacoma rental business license. So if you're operating business in the City of Tacoma, you are required to have a valid City of Tacoma rental business license. So if you don't have one, you need to go to the City of Tacoma's website, the tax and license website. It's an easy process. You can do it online, and you need to have a business license. So what we're thinking about here is you wouldn't be able to go through the show cause hearing. We haven't figured the whole process out, but the main point here is it would just basically be used to ensure that the landlord has their business license, because you have to have your business license, and that is the way that we do outreach to landlords. We do outreach to you to let you know when we have updates and all of this stuff, when we're proposing changes, when things have changed with us. So in order for you to know what you're required to do as a landlord in Tacoma, you have to have that business license. So if you don't have it, then you're not going to be in compliance. You're not going to be a good partner, because we look at this as a partnership. So in order for you to be a good partner inside the city limits of Tacoma as you're doing housing, you have to have that business license. So we're not saying that you can't do your eviction because you have a right to do it. You would just have to get the business license, which you can do it right there online, and then once you get the business license, and you would be able to schedule your show cause hearing or whatever. And so that's one of the things that we're looking at. So those are all of the, next slide, Alexis. Yeah, so those are all the proposed changes. So the next step is we'll do community outreach. We'll host community outreach events in all of the 4 sectors of the 4 police sectors, and then the council districts. And then we'll conduct focus groups and then surveys. There'll be some town halls, and we have a stakeholders group that we have every Friday. And it consists of landlord association, tenant associations, the real estate associations. We have legal representation from both landlords and tenants. We have shared housing partners, the Tacoma Pierce Housing Coalition to End Homelessness. We have the Tacoma Pierce County Affordable Housing Consortium. The Housing Authority is on there. We have City of Tacoma departments, the Health Department. And so we all meet every Friday, and what we do is we go through and we talk about each of the proposed changes. They come up with things that we might have missed as a city, and then the stakeholders, they go back and they talk to their audiences and then get the feedback. And then once we do that, we are in the process of drafting the code. And once I've drafted the code with the legal department, and when we draft the code with the legal department, we come back, we'll look at that as a group, and then we'll edit it and do all of that. And then we'll take it back out to the community, get input, and then like we'll take it to council, and then we'll get council input. And then from there, we'll see where council, if council wants to pass it or if they want to go in a different direction. So next slide. And so for information about the rental housing code, we'll update, we're in the process of updating our webpage, which is there. And then you can, if you have any questions or if you need any assistance, you can do an intake online or call 311. And if you want information or provide information on a proposed changes, the information is there. The City of Tacoma Rental Housing Code or Tacoma RHC at cityoftacoma.org.